As per the Companies Act 2013, listed company means a company which has any of its securities listed on any recognized stock exchange. Before we understand the concept of listing, let us go back to the definition of the term company as defined under the Companies Act. The term company is defined to mean a company incorporated under the Companies Act 2013 or under any previous company law, that is, Companies Act 1956 or Companies Act 1913. Therefore, a listed company is essentially a company incorporated under the provisions of the Companies Act. It may be noted that no company can be incorporated as a listed company at the time of its incorporation. To better understand the concept of listing, let us make a flow chart. Say, A Limited had issued securities to public. Let us assume that such securities are issued in an IPO. The next stage after the issuance of securities is subscription of such securities by the public. Upon the subscription of the securities, the board of directors of the company shall allot such securities to the public. Post-allotment, such securities shall be allowed to be listed on the stock exchange after obtaining the listing approval. It is only after the listing of securities that the exchanges allow trading of such securities. It is important to know that, in order to list the securities on the stock exchange, the company shall comply with the regulations prescribed by the regulator. So, who regulates listed companies? It is the Securities and Exchange Board of India, which regulates the listed companies or companies proposing to list their securities on the stock exchange. Section 24 of the Companies Act empowers the Securities and Exchange Board of India to administer the following through its regulations. Number 1. Issue of securities by listed companies. Number 2. Transfer of securities. And number 3. Non-payment of dividend by listed companies. As such, the Securities and Exchange Board of India prescribes regulations which are applicable only to listed companies. Does the regulations prescribed by the Securities and Exchange Board of India override the provisions of the Companies Act? The answer is a strong no. It is important to understand that all the listed companies shall comply with the provisions of the Companies Act, as well as the regulations prescribed by the Securities and Exchange Board of India. However, whenever there is a conflict between the Companies Act and such regulations, the thumb rule is that the listed companies shall comply with the stringent provision amongst the two. For those of you who want to understand the functioning of stock exchanges in detail, you may refer to our video on Securities Contracts Regulation Act of 1956, Part 1 and 2. The link is provided in the description below. You may alternatively click the link on the left of your screen. With this, we finish our episode number 8. Do not forget to subscribe to our channel and stay tuned to more interesting videos on corporate law.